The judge spoke 4 words. The defendant's entire defense collapsed. In any American courtroom, one judge can legally silence everyone, and the Constitution can't stop it. In 2016, a defendant named Martin Shkreli walked into a federal courtroom. You might remember him as the pharmaceutical executive who raised the price of a life-saving drug by 5,000%. But here is where it gets strange. Before his trial even began, the judge issued a gag order. Shkreli could not speak to the press. He could not post on social media. He could not discuss his own case publicly. And when he violated that order, the consequences were swift and brutal. But the prosecution had one more witness. What the judge did next would become a landmark example of judicial power. This was not about guilt or innocence anymore. This was about control. And the question that haunted legal experts was simple. Can a judge really override the First Amendment? The answer will change how you see every courtroom in America. Think about that for a second. The First Amendment is supposed to protect your right to speak freely. It is the foundation of American democracy. Yet the moment you step into a courtroom, that right can vanish. Here is how it works. A gag order is a judicial command that restricts parties in a legal case from making public statements. Judges justify these orders by claiming they protect the integrity of the trial. They argue that pretrial publicity can taint the jury pool. And then the evidence changed everything. But here is the thing. The Supreme Court has repeatedly ruled that prior restraints on speech, meaning orders that prevent speech before it happens, are presumptively unconstitutional. So how do gag orders survive legal challenges? The answer lies in a legal loophole that most Americans have never heard of. Courts have carved out an exception for participants in legal proceedings. If you are a defendant, a witness, or an attorney, your speech rights are suddenly different. You exist in a constitutional gray zone where the judge has almost unlimited power over what you can say. Let me put this in perspective. In 1966, the Supreme Court decided Shepard v. Maxwell, a case that would reshape courtroom power forever. Dr. Sam Shepard was accused of murdering his wife. The media coverage was relentless. Newspapers printed headlines declaring him guilty before the verdict. Cameras surrounded the courthouse. The jury was exposed to constant coverage painting Shepard as a monster. What the jury heard next sealed the verdict. He was convicted. But years later, the Supreme Court overturned that conviction. They ruled that the trial judge had failed to protect Shepard from prejudicial publicity. And here is where everything changed. The court essentially told judges across America that they must control courtroom participants to ensure fair trials. This single decision became the foundation for modern gag orders. Judges now had Supreme Court backing to silence anyone they believed might compromise trial fairness. What nobody expected was how broadly this power would be interpreted in the decades that followed. Now here is where it gets truly disturbing. Fast forward to the present day, and gag orders have expanded far beyond what the Shepard Court ever imagined. Judges now issue them preemptively, before any media coverage even exists. They issue them against defendants who have large social media followings. They issue them against witnesses who might speak to journalists. But the defense made a fatal mistake. In 2023, a federal judge issued a gag order against a former president of the United States. The order prohibited him from making public statements about court staff, prosecutors, or potential witnesses. When he violated the order, he was fined $10,000. The second violation cost him another $10,000. But here is what most people missed. The judge had the power to do something far worse. Under contempt of court statutes, judges can impose unlimited fines. They can even order imprisonment. All without a jury trial. all based on their own judgment that you violated their order. This is power that exists in no other context in American law. But, everything I just told you? That is just the setup. Because the courtroom went silent when this happened. The real question is not whether judges have this power. They do. The real question is whether this power can be stopped. And the answer is almost, never. When you challenge a gag order, you must appeal to a higher court. But appeals take months, sometimes years. Meanwhile, the gag order remains in effect. You cannot speak. Your lawyer cannot speak. The media cannot quote you. And if you violate the order while waiting for your appeal, you face immediate punishment. But wait. There is more to this case. In 2018, former Trump campaign manager Paul Manafort was ordered not to contact potential witnesses. Prosecutors discovered he had tried to reach two individuals through encrypted messaging. The judge did not just fine him. She revoked his bail entirely. He went from house arrest to federal detention in a matter of hours. One violation. One judge's decision. His freedom was gone. And there was no jury involved. No trial on the contempt charge. Just a judge who decided he had crossed the line. And this is where justice was served. Or was it? What would you have done in this situation? The legal community remains deeply divided on gag orders. Civil liberties advocates argue they are a dangerous overreach. They point out that defendants are presumed innocent. Silencing them before conviction treats them as guilty. Defense attorneys argue that gag orders often benefit the prosecution. The government can hold press conferences announcing charges. They can release dramatic perp walk footage. They can shape public perception. Meanwhile, the defendant sits silent, unable to tell their side of the story. But prosecutors counter that trials should happen in courtrooms, not on cable news. They argue that social media has made fair trials nearly impossible. One viral post can poison an entire jury pool. Here is the twist. Both sides might be right. The research shows that pretrial publicity does affect juror perceptions. Studies have demonstrated that people exposed to negative media coverage are more likely to vote guilty. But the same research shows that strong judicial instructions can minimize this bias. What happened next shocked the courtroom. The Supreme Court has never directly ruled on whether gag orders against defendants are constitutional. They have danced around the issue for decades. Lower courts have been left to make their own interpretations. And those interpretations vary wildly. Some circuits apply strict scrutiny, requiring judges to prove gag orders are absolutely necessary. Others apply a balancing test, weighing free speech against fair trial rights. And some courts give judges almost complete discretion. The result is a patchwork system where your rights depend entirely on where your case is heard. A defendant in the Ninth Circuit might have strong speech protections. That same defendant in the Fifth Circuit might be silenced completely. But here is the revelation that changes everything. In recent years, appellate courts have begun pushing back. They have overturned gag orders they deemed too broad. They have ruled that judges must consider less restrictive alternatives. They have demanded specific evidence that speech would actually harm trial fairness. The tide may be turning. But for defendants facing trial today, that future reform offers little comfort. So what does this mean for you? Every American should understand that courtroom rights are different from street corner rights. The moment you become involved in a legal proceeding, the judge gains extraordinary power over your speech. This is not a bug in the system. It is a feature designed to protect fair trials. But like any power, it can be abused. The best protection is awareness. If you ever face charges, understand that a gag order may be coming. Work with your attorney to challenge overly broad restrictions. Document any violations by the other side. And remember that appellate courts are increasingly skeptical of sweeping gag orders. The First Amendment may not protect you inside the courtroom. But the legal system is slowly recognizing that silencing defendants completely goes too far. Now you know how one judge's silence command can override your constitutional rights. The question is whether that power will continue to expand, or whether courts will finally draw a clear line. That battle is being fought right now, in courtrooms across America. Now you understand the gag order power. A single judge can silence anyone in their courtroom, and the Constitution offers almost no protection once you step inside those doors. Subscribe for more courtroom breakdowns where we reveal how the legal system really works. What case should I cover next? Tell me in the comments. And if you think gag orders go too far, or if you believe they protect fair trials, I want to hear your verdict below.